we have a fantastic panel next with judges. So we've been very fortunate to have Judge Jed Rakoff be a friend of Berkeley and a friend of FraudFest and a participant, and we always are eager to have his wisdom. And I've known Vice Chancellor Laster for many times. He gave excellent comments to me on my book, Wait. I don't know if you remember that, but they're two of the leading judicial minds, and so we wanted them to be part of the conference. And then we were thinking about, okay, who can wrangle these two smart judges? And Usha has done a superb job in various contexts, including last year, managing a debate. I, as with several of these panels, have no idea what's going to happen. So I think you've had a prep call, I guess, to talk about this. So here we go. Usha, take it away.
We have no idea either.
So that's what I was going to say. We've had a prep call, but we're not exactly sure what's going to happen. I think it's going to be fun. But we're going to talk about. I mean, we've talked about the role of the courts and the role that enforcement can play, and now we have two main stage actors in that. And I think the plan was to try to go through, how this process will go, how fraud detection works from the beginning, getting through courts, and we'll see how that goes. I think either way, it's going to be a treat. So. I'll start by asking both of you, distinguished jurists, how do these fraud cases emerge in your respective jurisdictions?
The supremacy clause means you should go first.
In terms of age, so it depends what you mean by fraud cases. There are indictments by the Department of Justice. They come in the last couple of years, where there's been an increase, maybe 4 or 5 a year in my district, the Southern District of New York. Then there are SEC actions, which too often, in my view, are brought within the SEC, but occasionally they break down, and the Fifth Circuit has recently ruled that certain fraud cases cannot be brought before a SEC administrative judge and have to be brought in the federal court, and I'm all for that. Those are maybe, another 3 or 4 a year. Then there are securities class actions, which come with greater frequency. In my own, I'm just one of 40 judges in the Southern District of New York, but I get at least 5 of those a year. So if you multiply that by 40, that's a lot of class actions. Those, however, usually settle. And then there are individual fraud actions, some of which are in federal court because of diversity of citizenship, but some of which are in federal court because of other statutes, such as RICO, that allow civil actions as well as criminal actions to be brought for fraud. So it's quite a variety. Keeps me busy.
Sure. So our situation is a little bit different. So for background, I'm one of the judges on the Delaware Court of Chancery, which is a special trial court in Delaware. It's a traditional court of equity. So I can dilate on what that means, but let's just say for now, we do civil cases. And we primarily do civil cases involving corporate and business law, although there are other aspects of our docket. But I'd say about 75% of what we do is business-oriented cases. So how do things come to us? Well, what we lack is what you heard Judge Rakoff talk about the public enforcement mechanism. Because we don't have any criminal jurisdiction, we do not have anyone enforcing that type of lawsuit or bringing that type of proceeding in front of us. So our actions are private actors bringing these cases. And the bulk of the time that fraud claims come up, I'd say there are 2 scenarios. One is when an investor, typically a sophisticated investor, feels like they've been defrauded. So one of the early skirmishes in the Theranos litigation was an investment firm that thought that they'd been defrauded. They brought a case that was in front of me. It went through a bunch of discovery, but then, as with a lot of private company disputes, it's settled. And that's a key difference, I think, or a key factor that comes out of these types of cases. The other big type of case we have are deal-related cases, both private acquisitions and public acquisitions. And fraud is quite often, amazingly often, asserted as a cause of action in those cases. And it's usually not based on something that someone told you with a wink and a nod. It's usually based on one of the representations and warranties that appears in writing in the deal agreement. So it's established that if someone puts a representation in the deal agreement and simply doesn't comply with it, well, that might be a breach of contract action. But if someone knowingly signs a document with a representation in it, intending to induce you to enter into the deal, that can support a fraud action. So those are the two types of main fraud actions we have. The analog that we have to what Judge Rakoff is talking about in the sort of broader market-wide issues, we have a lot of fiduciary duty actions that raise scienter issues and loyalty issues, but they're not traditional fraud claims. The place where we mainly intersect with the securities actions that Judge Rakoff is talking about is if a company has suffered some corporate trauma, like an adverse result in a federal securities action, a stockholder of the corporation can seek to shift that loss to the people who actually caused the corporation to suffer the loss through a derivative action. So quite often what will happen is there'll be a securities action in the Southern District of New York, and then some other stockholders will file a derivative action in front of us saying, all those things that happen in the case in New York, people should be personally liable for that, the directors and officers, and we want you, Delaware courts, to adjudicate that. As a practical matter, we usually stay those pending the result of the hard work that folks like Judge Rakoff do, and normally those are wrapped up in the settlement that happens in the federal court, so rarely do they, in fact, I don't think they have ever resulted in any type of adjudicated result.
There's a piggyback aspect to this, which was just alluded to. The federal government, either in the form of a DOJ investigation for fraud or more often an SEC investigation for fraud, will only bring a small fraction of those cases. Partly that's due to lack of resources, but there are often other issues involved. Nevertheless, once word of that investigation gets out, then there will often be a class action brought in federal court, piggybacking over the what's been established through the public disclosures. And then, if that case is successful or settled, then there will be the derivative action in state courts. So there is a kind of trickle-down effect.
So I hazard to guess that if I had $100 for everyone in this audience, both here in this room and virtually, who, when Vice Chancellor Laster started talking about the Delaware Chancery Court and suits and acquisition, and reps and warranties in a merger agreement, started thinking about Twitter and Elon Musk, I might be a much richer woman. I'll probably defer that question until a little later on, and I'm not implying in any way that there was fraud in that particular mix, but I'm sure it's on people's mind.
A lot of people want to talk about it.
But I will ask, so Judge Rakoff, there has been a lot of conversation at this wonderful conference so far about the various roles that journalists and private and public enforcement actors can play. And I know we don't see that directly in the Chancery Court, but what do you see about the differences or what's your take on what's the more effective mechanism?
Some frauds are exposed through journalists. I frankly think it's not as common as it once was. When I was a kid, I was chief of the fraud unit in the U.S. Attorney's Office, and I would say maybe 25% of our cases then were brought because of articles we had read in the Wall Street Journal or Barron's or whatever. But most of the media does not have the resources or the desire anymore to have a reporter go off and spend 6 months looking into whether there is a fraud, and then only if they find there is a fraud is an article published. And so you don't see those kind of deep investigations as much as you once did. So in the cases, fraud cases, both civil and criminal, that I've had in the last, 10 years at least, I would say maybe one or two arose from journalists, much fewer than used to be the case.
And what about public enforcement versus private enforcement?
Well, there is, of course, first the piggyback aspect. So, I mean, consider it from the standpoint of the people bringing these actions. The U.S. Attorney, the Department of Justice, will frequently not bring an action, particularly against high-level executives, because they can get a quick settlement with the company. Whether the company admits it committed fraud or not, that's because of a federal doctrine called respondeat superior. We always like to use Latin phrases rather than English ones. And it says that the criminal acts of even the lowest level employee are automatically imputed to the entire company. That's not true under state law in most states, but it is true under the federal. So the result of that is, if you're a prosecutor and you find out that some low-level person has committed a fraud, that, for example, that some relatively low-level people at Wells Fargo have created fictitious accounts, you can, with very little difficulty, arrange to have the company either plead guilty or plead to a deferred prosecution because they're really stuck. But one unfortunate result of that is that you don't allocate the resources that you need to go after high-level executives. The SEC does bring actions often, not just against the company, but against high-level executives. But it is handicapped both by the fact that it can impose criminal sanctions, but also because of its long tradition, which I think is unfortunate, of allowing people to enter into settlements without admitting or denying the truth of the allegations. And that the result is that, hey, the SEC is accusing you of something, hey, we'll settle, we'll pay a few bucks, and we'll neither admit or deny that we did anything wrong, and the case goes away. Going one step lower to the class action attorneys, they're in it for the money. It's a very lucrative thing, but the Congress has made it ever more difficult to bring securities class actions unless there's very substantial evidence right in the initial pleadings, even before discovery. So many of those cases settle. And to put numbers on this, if we look at all criminal cases of all kinds, 97% of them are settled through plea bargains. If we look at how many executives, high-level executives, are prosecuted by the Department of Justice, until very recently, the answer for the last 15 years was 0. If we look at SEC cases, the great majority of those also settle. And if we look at class actions, they also settle, although usually not till after certification has either been granted or denied, because that's where the money is. So the bottom line, unfortunately, is very few of these cases get to trial, and the ultimate determination of whether there really was a fraud or not is often left unclear.
Vice Chancellor Laster, how does the world look? I know you don't have the public enforcement.
Yeah, we don't have the public enforcement initiation, but one of the dynamics that does play out is the journalism piece. And it's absolutely true that that is a big factor that sets into motion the players involved. So as in the class action cases that Judge Rakoff's talking about, a lot of the suits in our court are brought by plaintiffs who are represented by lawyers litigating on contingency for the reward of some ultimate recovery, either by settlement or judgment. So they are looking for situations where they can bring these types of suits. Delaware also has a high pleading burden to get past a motion to dismiss. It's not as onerous as the PLSRA in federal court, but still you have to plead essentially real facts to support an inference of fraud or an inference of breach of fiduciary duty. So the plaintiffs have to have something to get past a motion to dismiss. And the two big decision points in the case are the motion to dismiss stage and really then in our court, the trial stage, because of the types of cases we're dealing with. So a lot of the action happens at the motion to dismiss stage. And the big question is, have you pled enough to get past a motion to dismiss? Unlike in federal court, whereas Judge Rakoff says they use a lot of confidential informants and things like that, in our case, in our situation, the plaintiffs are either trying to make use of journalism, trying to make use of short reports, or what they will do is they will take the intermediate step of seeking books and records. There are statutes under Delaware law, particularly Section 220 of the General Corporation Law and analogous statutes under our other entity acts, that let you get books and records from the company. It's essentially a form of pre-suit discovery. And to get those books and records, you have to be able to show a credible basis to suspect wrongdoing. Not a big hurdle, but a hurdle. So in terms of the sequencing in our court, often there will be initial event that is either a federal securities law action or something of the type of thing that Judge Rakoff is talking about, or there'll be a journalism article, or there'll be a short report. And then based on that, a stockholder will come in and seek books and records such as internal board materials that they hope will show that they have enough to get past a pleading stage action. And then if they think they have something, they will bring the lawsuit. Contrast that with the deal cases that I was talking about. In those situations, it's a bilateral case where both parties have firsthand knowledge of what went on. And so the plaintiff in that case can typically come in and say directly, and it's usually, frankly, the buyer in a post-closing action. The buyer will say, look, we got the company, we have the emails on the servers, we've looked at them, we now think you lied to us as to A, B, and C.
Mm-hmm. Can you talk more about these confidential witnesses that go on in the federal?
For those of you who are not familiar with the PSLRA, the Private Litigation Securities Reform Act, this was passed by Congress because they thought that too many extortionate class actions were being brought on little or no basis. And because it's a class action, if it's certified, very big bucks are involved. And so there's a motive to settle early if you're the company. So in reaction to that, Congress passed this statute, which among many other things, says that you have to plead with particularity not only the facts of the alleged fraud, but also facts giving rise to a strong inference of fraudulent intent. So it's not enough to show that a particular statement was wrong. You have to show that it was intentionally wrong. And that's not an easy burden to meet before any discovery. So what the class action attorneys have increasingly done is seek out employees, usually former employees, who are willing, initially confidentially, although eventually if the case does go forward, their identities will be revealed, to give particular information giving rise to a strong inference of fraudulent intent. Like, I brought this to the COO's attention and he told me just forget about it, something like that, even though what I was telling him was a blatant fraud. That would be the typical kind of thing, spelled out with much more particularity than I've just indicated in the pleadings. Now, I had a case about 5 years ago where the CWs, the confidential witnesses referred to in the complaint, were present employees, current employees. whistleblowers, if you will. And the company then got their names as discovery went forward. And while it's conceivable that the names could be sealed, in many cases, the company will figure out just from the information given who the employee is. And they took the depositions of these employees who all denied they had ever said this. So I held a hearing, and what came out was that under oath, the employees admitted that they had stuck by the allegations that they raised of fraud in the company, but also said that the reason they denied it to the company because they were afraid of retaliation since they were still current employees. Now, this is a problem of the whistleblower, and the SEC makes very heavy use of whistleblowers and can protect the whistleblowers in SEC actions. But in private actions, the protection is not statutory and is more difficult. And the result is that in most of the class actions that I'm familiar with, the CWs have tended to be former employees rather than current employees.
Do whistleblowers play a role in Delaware cases?
We have not had that trend. We have not seen that trend. Certainly some of the firms that practice in front of us also practice in federal court as well, and so they're familiar with it. But to date, the confidential witness approach has not permeated our docket. Our docket is mainly an effort to get the documents and then point to what the documents say.
Mm-hmm. Well, then we move to trial, where you're both center stage. And I know that, so you have both bench trials and jury trials, Judge Rakoff.
Yeah, I hate bench trials because they're a lot of work. But yes, we have both, and I am a very great believer in the jury system. I think there's a view held by judges abroad that I've talked to at various times. How can you have the jury system? How can those people ever decide a complicated securities case or complicated fraud case? I think that's all totally wrong. The key to the jury system is that it has to be unanimous. And so, of course, you have people of varying intelligence, varying perceptions, varying biases for that matter. But the only way they can arrive at a verdict is by talking it out and reasoning and looking at the evidence and coming to a conclusion that they all can buy into. So my experience is very positive about the jury system, and I really prefer it to the bench trials for another reason, which is I think it's democracy in action. There are very few places left in our justice system where individuals who are not judges, who are not lawyers, can play a meaningful role. There are very few places in our society where everyday individuals can play a meaningful, immediate role in determining what justice is and where the truth lies. And the jury system gives you that opportunity.
Yeah, I'll speak from personal experience. Whenever I get called for the jury, I'm always struck by how almost poetic the judge is in explaining the role of the jury. And then I always get struck because I'm a law professor, so that's good. So what about Delaware being so anti-democratic? What's going on?
Exactly. I pine for the jury system, particularly when I'm writing these 100-page plus post-trial decisions. So remember what I said at the beginning, which is that we're a specialized court of equity, which is really a holdover from, believe it or not, a medieval system in England that had persisted through 1789, and hence we all inherited at the time of the separation. So we do have a court of general jurisdiction in Delaware. It's called the Superior Court. They do juries, they do punitive damages, they do all the things that you'd think of in a regular court. It's only in the Court of Chancery, which is a court of equity, where you cannot get a jury. So what I often tell people at the beginning of the case, and lawyers tell their clients, is, you know, if you draw me, you've drawn me. You'll have me through the whole case. I'm going to be deciding your motions. I'm going to be presiding over the trial. And then I'm going to be deciding the facts and applying the law and issuing a long decision that tries to spell all this out. at which point you'll finally be able to get away from me and take an appeal. But that is how things go for us. And so I end up being the fact finder in pretty much in every case. The one step that we jumped over, which parlays into trial, is discovery. And after the initial motion to dismiss, the lawyers go out and do tons of work, and that's where the bulk of the case happens, is in discovery. And at least in my experience, just as the journalists were speaking with us today, the documents really matter. You can't win at trial if you don't have the documents, because there is never a defendant that will come in and admit to committing fraud. There is never a defendant, particularly a well-advised, well-represented defendant, who will come in and admit to breaching fiduciary duty. They will all have excellent explanations and accounts of what went on. And the only way for a plaintiff to overcome that, because they weren't in the room at the time, is with documents. And often that does mean, these days, text messages. We're in a post-email world. Now it's the text messages, it's the Slack documents that people have to try to get. And so the trials, at least in our court, often shape up to a battle between what the documents say about what seems to have transpired. And these are documents that are often being produced in real time by people using their devices as they're at meetings. So what the documents suggest that has transpired, and then what the defendants come in and testify about what transpired. And so those are the two different stories that one has to decide between at trial.
Thank you for
I should add that many polls over many years have all rated the judges of the Delaware Court of Chancery at the top, the best judges in the United States.
Very
and I'm delighted to see that, because the Supreme Court is usually down at the bottom.
Nice of you to say, Judge.
So I'm going to pull back and ask a big question about how good this legal system that we have is at detecting fraud or prosecuting fraud, right? Maybe even preventing fraud, and whether that looks different state versus federal.
Well, I think, I apologize if this sounds a little extreme. I think there's no doubt there's a double standard in this country when it comes to the legal system. There's one law for the poor, which tends to be very harsh, especially in criminal cases. And that's why we have mass incarceration. And there's another law for the rich, which tends to be very lenient and very forgiving. And the rich, it mostly plays out in fraud cases. This is, in some ways, a new development, strangely enough. In the late 19th century, under the leadership of Teddy Roosevelt, the Department of Justice began to go after high-level executives who had orchestrated frauds. And indeed, I'm reading just now a biography of Felix Frankfurter. Felix Frankfurter's first case was as an assistant U.S. attorney in the Southern District of New York, where he prosecuted the head of what was called the Sugar Trust, a monopoly that had 98% of all the sugar refining marketing in the United States, and concealed it through a variety of schemes, and he convicted. And this continued to be the position of the Department of Justice as recently as the turn of the 21st century. So in the late 90s, 1990s, and the early 2000s, you had the prosecution of the CEOs of Enron and WorldCom and Tyco and Adelphi, and you can just go down the list. That all ceased starting around 2006 or so, and it ceased regardless of whether the president was a Democrat or Republican, and it ceased whether the attorney generals were quote liberal or quote conservative. And that was because of this doctrine of respondeat superior that I mentioned before, that allowed the Department of Justice with almost no effort to get a big settlement, lots of money, big headlines. Bank X just settled for $1 billion. We caught them. But they never took the time, the effort, which took years, but was successful in Enron and WorldCom and so forth, to find out how high a person was responsible for that fraud. After all, companies don't commit frauds in any real sense. It's some human being or group of human beings who make the decision whether or not to commit the fraud, sometimes at a low level, sometimes at a high level. And the Department of Justice very recently, in statements issued in the last 6 months or so, 9 months, has said it's going to go back to focusing on high-level individuals. I hope that's true. It hasn't yet had time to develop one way or the other. But until then, it's hard for me to escape the conclusion that our justice system has deteriorated in terms of going after who are really responsible for some of these massive frauds.
5 seconds on Elon
5
Musk.
seconds. In the civil context, I think we have over-enforcement in some areas and under-enforcement in others. We have over-enforcement where there's a high-profile defendant or corporation, a lot of money, it attracts a lot of people to the light, and so there's over-enforcement there. We have under-enforcement in quite a number of areas, particularly small-cap stocks, where there isn't the amount of money at issue in the case to get real lawyers involved. And a lot of times, as you go down the market cap size, the lower you go, the lower you go. And so it really is true, I think, that in those areas where we need the most enforcement, the private law enforcement mechanism breaks down because the amount in dispute isn't enough to drive the private actor remedy on which we primarily rely.
Well, I was going to ask the last Elon Musk question, but we're out of time. Maybe 30 seconds. What's going to happen? Tell us in the Delaware Chancery Court.
We will someone on our court, and the chancellor gets to decide who gets the case. That's part of the privilege of being the chancellor. But someone on our court will give it serious attention. I can blissfully say I know nothing about the details, but having done MAE cases in the past, I know that whoever it is will look at the drop dead date. They'll back up from the drop dead date enough time to give them the ability to do a decision, and then whatever that amount of time is, it'll get done. If it's 1 month, it'll get done. If it's 4 months, it'll get done, and there'll be a trial in that time frame and a result for somebody to appeal.
Well, thank you very much. I'm sorry we don't have time for questions.